Should we start, or do we want to wait for people to file in?
Yeah, let's wait.
Okay. So I was going to introduce your presentation first.
Sounds good. Yeah. I'm using your presentation as an opportunity. Sorry, I have my laptop. Things to steal. And you've also got the book review process. Seth. Actually, there's currently a section, I'm rewriting our intro, and there's a section that says gender here. Well, I also have my, I think when I sent out the draft to you guys, it was Emily and Chloe book, and it's now very formal. Forthcoming. So tough. Other country.
What do you think? All right, let's do it. Welcome, everyone. Thank you for joining us today. I want to thank special thanks to Katie Aker for handling all the logistics on this. Thanks to Nazbama for the support of this. My name is Seth Maskett. I'm a professor in the Department of Political Science here. I'm also director of the Center on American Politics, which is over here in the Scribner Institute on Public Policy and the Corbell School of International Studies. You are all joining us for an interesting, topical, and unusual event. This is essentially a conversation between two different books. The topics are different. They cover a range of vital issues in American political development, all of which intersect with race and gender and class. We'll be focusing specifically on the development of rights in the United States, the politics of debt relief, and women's rights. And if you thought those were old and arcane topics, this week should have really disabused you of that by now. I will first mention our visiting scholars here. Chloe Thurston, there on the end, is an assistant professor in the political science department and faculty fellow at the Institute for Policy Research at Northwestern University. Dr. Thurston's research is on American political development, political economy, and public policy, with a particular interest in how politics and public policy shape market inequalities along the lines of race and gender. She's previously the author of a book, At the Boundaries of Homeownership, Credit, Discrimination, and the American State, published by Cambridge, and she holds a PhD in political science from the University of California at Berkeley. Next to her is Emily Zackin, who is an associate professor at Johns Hopkins. Her research focuses on the development of rights in the United States and state legislatures, especially the development of education rights, labor rights, and the environmental bills of rights. She is the author of Looking for Rights in All the Wrong Places, Why State Constitutions Contain America's Positive Rights, published by Princeton, and she holds a PhD in political science at Princeton. Together, Drs. Thurston and Zackin are completing a book entitled The Political Economy of American Debt Relief. This book examines 19th century demands on the government for debt relief, which helped develop the argument that government has the obligation to protect people from financial ruin. This movement's at the core of the development of the social safety net throughout the 20th century. However, first, we're going to hear from my colleague, Dr. Sara Chatfield, who is an assistant professor of political science here at DU. She's also a faculty affiliate this year with the Center on American Politics. Her research focuses on American political development, women in politics, and political behavior. Some of you may have attended her classes on constitutional law or judicial politics, or her freshman seminar on the politics of bathrooms. She is in the process of completing a new book called In Her Own Name, The Politics of Women's Rights Before Suffrage, in which she examines the development of women's property rights across the United States in the 19th century. Hint, they didn't all show up first where you would expect them to. Dr. Chatfield holds a PhD in political science from the University of California at Berkeley. So the way this is going to work, we will start off with Sara Chatfield describing some of her recent research for about 20 minutes-ish. And then we will go over with Thurston and Zackin. So the floor is yours.
Awesome. Thank you so much, Seth. And thank you. To everyone who made this event possible, and many thanks to the COVID gods. Our first round of trying to do an in-person event together was thwarted by Omicron. And so I'm really glad that you guys are both able to be here today and that we get to talk about debt and rights together. So what I'm going to cover today, I'm going to give a little bit of background on married women's economic rights in the 1800s. For those who don't know anything about them, many people have heard me talk a little bit about this project at times, or a lot. But give a little background. I'm going to talk about the theory in the book a bit, and then do a little bit of more focused discussion of debt relief in particular, where there are a lot of overlaps between our projects. So I'm going to start with setting the stage with a historical term, coverture, and this describes the legal status of married women for most of US history before the period that I'm going to be looking at that started in the 1830s. This is based on British law, and it was a legal principle that when women got married, their legal identity was merged with their husband, and they didn't have any independent legal, civic, or economic identity pretty much at all. They couldn't own property or sign contracts or appear in court under their own name, take out loans. There were some exceptions in some states, but they were mostly ad hoc, and generally women would give up their rights to sort of act as their own person in the economic sphere when they got married. And this began to change with the passage of Married Women's Property Acts and related reforms in the mid-1800s. So what did these reforms look like? They were passed in states, not at the national level, and they happened in all state legislatures, as well as in many state constitutional conventions between around 1835, and the period I look at is through 1920 with the ratification of the 19th Amendment. And I want to emphasize these were very incremental. So it did not tend to be the case that a state would just pass a law and sort of be it. We're here, right? You would tend to see the passage of sort of incremental reforms over time. And they varied by state, but often included many of the reforms listed here. So things like protecting separate property from a husband's debts. That's the one I'm going to be focusing on at the end of the talk today, as well as more expansive and revolutionary rights. So things like the ability to appear in court, to sign and enforce contracts, to own wages, testamentary rights, so the right to write a will. So a whole variety of economic rights that were granted to married women. And this map shows the passage of one of these kind of more limited types of laws, and the one I'll be focusing on primarily today, which allowed married women to hold separate property that could not be taken by creditors if her husband got into financial trouble and had a lot of debts. And she couldn't necessarily control or sell that property, but she could own it and kind of keep it protected from creditors. And so in this map, the lighter colors are indicating states that passed this reform earlier. The darker colors are states that passed it later. So that ranges from the earliest territory, Arkansas in 1834, the earliest state, Mississippi in 1839, as Seth said, not necessarily the places you expect this, through the last state, Oklahoma in 1890. And one of the key questions that I want to ask in this book is around the fact that married women gained these economic rights before they had political rights, at least in most states. So the 19th Amendment, granting women the right to vote at the national level, was ratified in 1920, and every state had passed at least some form of these economic rights reforms prior to that date. Of course, some states did grant all women the right to vote at the state level before 1920, but even there, almost all of them granted at least some new economic rights before extending those state level voting rights. And so that made me ask the question, why would these male political actors make the choice to give up their economic power and give it to women, especially when women had very limited political power and also just very limited power at all to pressure them and make them do so? Why would economic rights come first, and what are the implications of that ordering? And part of the answer to this question, right, is men were benefiting from these laws. They weren't just giving something up and losing out and doing this out of the goodness of their hearts. But the theory I develop around this is that married women's property rights reform took place through kind of this two-level process. On one level, policy was developing in individual states and cycling through state level institutions with their own institutional logics. And you can see sort of how I've mapped out this process on this slide, where you have a variety of movements and secular trends and state building goals. I don't know how easy that is to read on here, but some of the ones that are listed there are things like the codification movement, which was really focused on rationalizing the body of law in a state, not limited to laws having to do with women, but just in general, trying to get a consistent code of laws in state law. We have economic crises. I'll talk about those more in a minute, as well as the Homestead Exemption movement, which I'll also talk about more in a minute. We have a desire to expand westward. We have the women's movement, we have the temperance movement. All of these things in various ways are able to see married women's economic rights as allowing them to accomplish their goals in some way. And while some of them, like the women's movement, are focused on other types of rights for women, some of them are pretty disconnected from that. And then once these laws get passed in the first place, they start to cycle through state level institutions. So statutes are interpreted by state courts. State constitutional conventions are elevating the rights to constitutional status. And then state courts are interpreting those constitutional provisions. And then state legislatures are seeing, here's how state courts have interpreted this. It's not working out so well for us. It's really confusing for everyone. We'd better pass some new laws. And so you get sort of this cyclical process. But reforms weren't just developing in individual states, they were also spreading across the nation. And I look at this in a bunch of different ways in the book, but kind of putting this all together, we have state legislatures who are aware of what's going on in other states, of statutory developments in other states. They're seeking out policies that work. They're also identifying, oh, California did this and it really was a mess. We don't want to do it that way, right? Convention delegates at state constitutional conventions are trying to determine how do we avoid the pitfalls of what's going on elsewhere and also what's working, right? So they're also bringing ideas with them. They very carefully studied these constitutional compilations that were just sort of like all the constitutions of other states. And then state courts are citing out-of-state decisions on related issues, and this all kind of then feeds back into that institutional cycle. But the piece I'm going to focus, so that's kind of the broad theory, and I'm happy to talk more about it in Q&A if folks would like. But what I want to kind of dig into in a little bit more detail today is looking at how all of this related to issues of debt relief, and that'll give us some nice overlap with the other book that we'll be talking about today. But I'm going to kind of quickly hit on 4 topics here. And again, happy to go into any of this in more detail during Q&A if folks would like. But I want to give you an idea of what these laws looked like. And then I'm going to talk about debt relief in the context of slavery in the antebellum South, connections to the Homestead Exemption movement. And then finally, I'm going to give you a sense of some of this spread of these policies across the states. So first, to look specifically at what debt relief laws aimed at married women actually did. So this gives you a sense of sort of the working definition of these laws that I used in the book, sample language. This comes from Dakota Territory, and then just some basic descriptive statistics. But in general, these reforms allowed married women to hold certain types of property separately from their husbands. This was often referred to as a debt-free separate estate. And it codified some rights that wealthy married women had had in quite a few states earlier, but it made it available to all women in the state. So the type of property covered by these laws varied, but it included things like property that women had owned before they got married, property that they inherited while they were married, gifts they received from people other than their husband, so maybe from a parent, might include real estate, personal and property like clothing or household goods, And enslaved states prior to the Civil War also included enslaved human property. And this separate property would typically be required to be registered in the area where the woman lived. And then after it was registered, would no longer be considered liable for her husband's debts. Some of these laws were more expansive and gave women more ability to do something with that property, but many of these laws provided only for that ownership piece and the protection of the property from creditors. So they functioned primarily as a form of kind of family level debt relief with the control and management of that property, and sometimes profits gained from the use of the property remaining firmly with the husband. So 47 states and territories passed these laws, and the median year when they were passed was 1855. So to give some context here, this is a political cartoon from 1837. We see a poor family in a one-room attic apartment. The children and the mother are asking for food. There are these two guys at the door sort of asking for rent. And this reflects a lot of concerns with the economy at the time. The 1800s and early 1900s was this time of kind of boom and bust in the economy, lots of these crises and panics, of which economic historians have just identified a litany of different ones from these years. The economy was chaotic and individuals had to deal with these increasingly complex credit markets and widespread bankruptcy. And compounding the impact of that was sort of a changing role of debt itself in the economy and a growing middle class. So debtors were increasingly coming from all parts of the class structure. And so issues of debt relief began to really matter to more and more people. And the middle class itself was also growing, which was creating a class of more people who had wealth in their family that they wanted to protect and not see it go to waste. And so this unstable economy and these growing ranks of debtors became this backdrop against which legislators were considering policies like debt relief for families and women. And for laws that included these debt relief provisions, the goal was really not necessarily, or sometimes not even at all, the empowerment of women, but rather being able to set aside a portion of family income that could be protected from creditors. Apologies. There we go. Oops. So this, I want to look at in a little more detail. This image here is from Mississippi's debt relief law. And this was passed in 1839, again, as the second in the nation, but the first state, and was passed in the wake of the Panic of 1837, which hit Mississippi particularly hard and created a recession that lasted until the mid 1840s or so. And Mississippi lawmakers extended debt relief to citizens through a variety of measures, including a Married Women's Property Act. The Married Women's Law that you can see a piece of up here was introduced by a Senator, Hadley, who introduced two related bills during that session. The first one was for his personal relief. It was a private bill saying, I would like the state of Mississippi to forgive debts that I owe the state. And the other one was for the protection of married women's property from her husband's debts. He was apparently in serious financial trouble and was seeking direct debt relief for himself, as well as more generally through this protection of married women's property. And historical sources here vary a little bit on exactly what his marital status was, but they all kind of agree he stood to benefit financially from this. And so in looking at this law in particular, we can see both personal motivation for debt relief, as well as these broader concerns for that in the polity of the state. But this bill did not address all types of property that a woman might bring into a marriage equally or equivalently. So there were 5 provisions of this bill. 4 of them dealt specifically with enslaved human property, and that was a pattern that was repeated elsewhere in the South before the Civil War. So in slave states, giving married women ownership of enslaved people that they brought into their marriage was one way for lawmakers to prop up the slave economy in this period of economic instability. In both the 1850 and 1860 censuses, almost half the wealth of the South was in the form of enslaved human property. And beyond just their dollar value, enslaved human property was especially valuable in being used as collateral for loans. Enslaved people were seen as being easily seized and sold. They were highly sought after in the Southern economy. And as such, the quote unquote protection of this property from debts became a major goal of Married Women's Property Acts in the antebellum South. At least 5 slave states, including Mississippi, explicitly listed enslaved people in Married Women's Property Acts, and most treated them differently than other sorts of property. One example of that would be ensuring that the husband would have control and management of his wife's enslaved human property. And Southern white women were especially likely to hold enslaved people as property compared to other things that they might own. So even before the passage of these laws, wealthy slaveholding families had gifted and bequeathed enslaved people to their daughters and used a variety of legal mechanisms to sort of make that, make sure that their family could retain control over those enslaved people. Historian Stephanie Jones Rogers argues that parents were especially likely to give enslaved people to their daughters as opposed to other things like land, right? And her research is corroborated by a lot of state-specific evidence from other scholars. And because husbands would typically retain control over the profits from the work that his wife's enslaved people were doing, these laws operated to provide sort of this continuing revenue stream and economic stability for slaveholding families. So the next thing I want to mention is the Homestead Exemption movement. I think you guys are going to talk a little bit about this too, maybe. Yeah, possibly. So this was another 19th century social movement. And when we hear homestead, I think a lot of us think about the Federal Homestead Act. This dealt with the distribution of land held by the federal government to Western states. But Homestead Exemption Acts were laws at the state level that were becoming increasingly common starting right around the same time as Married Women's Property Acts. And what they would do would be to exempt a sort of portion of family property and usually land and personal property up to a certain value owned by the head of a household from seizure for debts. This often included specific protections for wives, such as requiring a wife's consent to either mortgage or sell a homestead. And supporters often advocated for Married Women's Property Acts or even packaged them together in one law because they both had sort of the same fundamental goal, right, of protecting a portion of family property. And as Emily and Chloe discuss in their study of homestead exemptions and debt relief, because of sort of pre-existing racial patterns in property ownership, any policy that was designed to keep land in the hand of current owners and not have it potentially go on the market in a foreclosure at a reduced price, right? Oh, sorry, that's me. That's going to have the effect of making it more difficult for Black people to purchase land, right? If you think about a set of property arrangements where most property is already owned by white families, then debt relief measures that allow them to keep and hold on to that property, especially land, makes it harder for any other group to break in, right? And this same principle applied to the debt relief versions of Married Women's Property laws, which similarly kept property, including land, off the market. All right, I'm reaching the end of my time, so I'm going to skip this statistics slide, but I'm happy to talk about it in Q&A if folks would like, because I want to just very briefly talk about kind of a final important thing to mention here, which is the role of settler colonialism and its connection to Married Women's Property Acts. The settler quality of the American empire meant that single men moving to the frontier were really not sufficient to achieve goals of state expansion. Families, which required women, were needed as this critical component of settlement. And because white women were seen as essential to this project, men on the frontier had this interest in granting them increased rights in order to incentivize them to move west. Ultimately, in a lot of ways, we can think about economic citizenship as being extended to some women in order for colonial power to expand. And this is relevant to all different types of reforms, but these separate debt relief laws were the most commonly passed type of reform among the territories before achieving statehood. So 65% of territories adopted this type of debt relief estate bill prior to statehood. And so together, when we think about this constellation of state laws and policies relating to married women's rights, the particulars varied between regions and varied between states and territories, but they added up to the system in which white married women were granted substantially greater protection for their property by state governments than were Black and Native women who were losing out from these different processes that were going on. All right, so I think I'm out of time. So I'm gonna also skip sort of spread among states, but I'm also happy to talk about that during Q&A if folks want. And thank you guys. And I'll pass this off to you.
Briefly, I wanted to mention we're going to move on to the second talk, but for those of you watching on Zoom, if you have questions that you'd like to ask, please feel free to type them into the Q&A thing at the bottom of the screen. If you are here in the room, please feel free to make yourself at home to any of the delicious food that we have, cookies, burritos, and a bag of lemonade. So we will now go with Thurston and Zackin.
Oh, and I think we
gotta
need to
change
get-
and we have to
or
figure that
I
out.
could finish on this.
I think we should. I think I need to open it and then share. Yeah. Lots of COVID times experience. Does
Oh,
that look
great.
good from your end, Katie? All right.
Okay, great.
Well, thanks again for the invitation. Thank you, Sarah and Seth and Katie. So we're going to try to provide a bit of an overview of a book project that we are getting towards the finish line on, but actually it's plastic enough, as Emily has pointed out, that we would also be really interested in feedback and able to incorporate it right now, including on the title, which is tentatively titled The Political Economy of American Debt Relief, but has also been called Debtors, Debt Relief and American Political Development, and actually just sort of changes each day. So if anybody has a title suggestion that will pass muster with our press, that would be wonderful. So just to start though.
Oh, wait, we have to.
Yeah.
Yeah.
I need to do it on here first.
I'm gonna ask for
now
my
it might
time
work.
back. For
See
this.
if it works now.
Okay, so this is a photograph of a protest, but it's staged by a group called Strike Debt. This emerged from the Occupy Wall Street movement. And Strike Debt urges debt resistance. And the basic argument of Strike Debt is that people shouldn't have their life choices and life chances constrained when debts become impossible for them to repay. They shouldn't be sort of permanently trapped under this boulder that they're trapped under in here. And their argument is that borrowers shouldn't have to bear so much of the risk that's inherent in any loan or credit transaction. And among other tactics to pursue this argument, they suggest that people collectively refuse to pay quote unquote illegitimate loans and doing things like defending foreclosed homes too. So we like to start with this because the idea of resisting repayment of one's debts might strike you as both newly hatched, something that's certainly come up in recent years too, and we're discussing in recent days in the student loan movement. But our current book project uncovers a much longer history of debtor protest in the United States. Debtors like this making demands very much like strike debts. And what we argue in the book is that these debtors have been important in shaping America's political development. There. So the picture on the left is of Shays' Rebellion. Shortly after the American Revolution, men from rural Western Massachusetts marched in army regiments on courthouses and freeing debtors from prison, threatening armed rebellion against the state government if it continued to enforce private debts and collect tax debts. In the next photograph here on the right, or it's my left, this is over a century later. But what we see here are farmers gathered en masse in Nebraska. And what they're doing is trying to prevent a foreclosure auction. They don't want this to move forward. And again, in order to enable indebted farmers to stay on the land. So we like to put these pictures side by side because, again, sort of like, Strike Debt, it conveys the continuity in debtor protest across over a century of American history. And again, starting after the American Revolution, we argue, and continuing through the Great Depression, over-indebted people, and we should clarify, and we do in the book, and I'm happy to talk about this more in the Q&A, but we'll also talk about this more today. This is often over-indebted white farmers, repeatedly demanded that the government help free them from ruinous debts. And what we do here in this book is call attention not only to these recurrent demands for debt relief, but also to the dramatic results. Again, debtors shaped American political development. So I want to highlight 4 arguments. That's difficult to do in 20 minutes, but I'll try my best. But as it's framed right now, again, we make 4 arguments. The first is that the proponents of protective debt relief policies in the 19th and early 20th centuries worked to denaturalize debt. And what we mean by that is they worked to point out that the government had choices about who would bear the risk that's inherent in a loan. What they argued is that borrowers did not deserve to bear the entire risk for economic calamities, especially those calamities that were so often beyond their control, much like the economic crises that Sarah was just describing in 1837, for example. And these borrowers recognized that the government choices were that there were government choices behind these economic experiences, like foreclosures, and they insisted that the government revise its role in these contracts and in these relationships, offering debtors economic protection rather than helping lenders enforce their contracts. We argue and we show in the book that this worked to some extent. The federal and state governments met many of these debtor demands. So our second argument is that this shift from enforcing debt contracts to protecting debtors required concomitant shifts in constitutional understandings. And indeed, the meaning of the US Constitution had to shift to accommodate these new federal protections for insolvent debtors. Third, we argue that the political economy of the post-New Deal 20th century made it much harder for debtors to organize around debt relief issues, and at the same time facilitated creditor organizing. And then finally, throughout the book, we emphasize that even at their most robust, these debtor protections shielded predominantly white middle-class Americans to the exclusion of, and sometimes even at the expense of, and again, I think Sarah documents and demonstrates this very well, communities of color. And so I want to use the rest of the talk to flesh out each of these 4 assertions a little bit better until Seth tells us that we are past our time. But first, so denaturalizing debt collection. Again, so for most of American history, farmers have announced their need for debt relief. And so this is a farmers organization newspaper. This is from 1936. And you can see here from this big banner headline that they are very unafraid to trumpet their over indebtedness, right? This is in the headlines. It's actually not a secret, although stigma is often associated with debt and considered to be one of the reasons that debtors don't necessarily want to organize and make sort of like a public demands for debt relief. And in the 19th century, farmers didn't just argue that their debts were oppressive. They argued that the government should decline to enforce them. In enforcing private debt contracts, they insisted that the government wasn't acting in a neutral or apolitical way, but was in fact siding with powerful creditors. Farmers insisted that the government had choices about how to behave when a loan couldn't be repaid, and that the government could choose to protect the debtor, effectively redistributing money from the creditor to the debtor and risk from the borrower to the lender. And so I'll give you just a moment to read this slide. This has an example from 1890 of this kind of argument. Oh, this is legible. So the 19th century was characterized by these recurrent economic contractions. Again, Sarah mentions the Panic of 1837, and we have this year as well. And these contractions also taught 19th century farmers organizations that debt relief was an important issue for them. What we found is that in the wake of each of these episodes, organized farmers demanded relief. Up through the New Deal, states were typically the first movers in protecting debtors, and many states passed debtor protective laws. Again, protections like foreclosure moratoria, which were a part of a class of legislation known as stay laws. And these would prevent anyone from enforcing debts for a certain period of time. Another type of common debt relief is known as an installment law, and these allowed debtors to repay their debts in installments over time. And then some statutes required creditors to accept payment in depreciated currency as well. There's sort of a large range of different ways that debt relief is sort of carried out over this time. But what makes this practice especially noteworthy is that most of these laws are at least arguably unconstitutional. And they were overturned about 2/3 of the time that they reached state high courts, and yet states kept passing them. So we talked about the state, but I also want to talk about the federal government, because the federal government was also sporadically involved in debtor protection over the course of the 19th century, and primarily through bankruptcy law. So Emily and I are looking for a way to visualize the development of US bankruptcy policy. So what we have here is an effort to do that. It is far from the final effort, and so again, we'd love feedback and we'll take questions. But basically what we did with congressional bankruptcy statutes is we gave statutes a single point for every protective feature they included, and then subtracted a point for every provision that specifically denied a protection. So the higher the score on the y-axis, the more protective the law. And we separate this between, sorry, I hope you can see this, the blue dots are involuntary bankruptcy, and the red triangles are voluntary bankruptcy. And so the first half of our book is about the construction of a social safety net, an imperfect social safety net to be sure, but in the form of debt relief laws, and the changes in constitutional meaning that those developments brought about. Although over the course of the 19th century, these laws were only in place for short periods. Oh, it's a little difficult to see that on here. Not until 1898. I don't know how well you can see the gray portion on the screen. Okay.
I think you have a laser pointer there.
I
Maybe.
don't trust. Yeah, anyway, I think I do. But so we gray that out after 1898 to reflect the permanence of the law. At that point, it was no longer a temporary measure. But even before that era, what we see here is a ratchet effect with respect to protective debtor features. And so after sort of each subsequent round of policymaking ends up incorporating some of the previous features of the last law, but also including new ones, again, sort of changing the nature of the provision of debt relief and the types of demands that debtors are making as well. So I think I'm happy to answer more questions about this. But what I want to in the Q&A, the one thing that I want to draw your attention to, because this is one of the themes of the book, is the sort of the rise and fall of protective debt relief here. And so what you see is that there's a climb in protectiveness over time, and then there's a fall with the Bankruptcy Act of 2005. And so one of the things that we demonstrate in the book is that this climb in protectiveness, again, required constitutional change. And in fact, each new law, as they ratchet up on this upward slope, generated new constitutional controversies and ultimately expanded the federal government's capacity to protect debtors. I'm going to say a little bit about this. So the Constitution explicitly empowers Congress to pass bankruptcy laws. Here we go. But as with so much of the US Constitution, no one ever really agreed on the meaning and the implications of this text. And yet each time Congress passed a new law, a new protective law, critics argued that the bankruptcy clause didn't really give Congress the power to debtors in this particular way. Each time, though, the new protection would stick around and would become part of an expanded understanding of the federal government's bankruptcy power. So just one example here. This is the show The Office. This is, I don't know if you recognize, this is Michael Scott. He's a sort of the bumbling regional manager, and he finds himself deeply in debt, and he receives advice that he should declare bankruptcy. So he walks into the sea of desks where his employees sit, and he yells, "I declare bankruptcy." So you don't just get to declare bankruptcy, but actually you do. Debtors can initiate this proceeding, and that was emphatically not the original understanding. In the earliest American statute, creditors had you declared a bankrupt because they needed the state's help to sell all of your assets and then to distribute them fairly, perhaps to punish you for your inability to pay them in full. It wasn't a good thing to happen to you. It was involuntary. And again, the chart before sort of separated out involuntary and voluntary. So in 1841, Congress created voluntary bankruptcy. This voluntary form of bankruptcy allowed debtors to choose to liquidate their assets for division among their creditors in exchange for cancellation or even discharge of any remaining debts. And creditors' permission was not even required to secure this discharge. In fact, a discharge was the normal result of the voluntary bankruptcy process and only could be blocked if the majority of the creditors in both number and amount filed a written petition against it. So this new use of the bankruptcy power to create this process through which the debtors themselves could seek to shake off their existing debts provoked enormous constitutional controversy. Same one. So this is Thomas Benton. He's a Democrat from Missouri, and he says that when Congress is Congress is debating the bill, that this just can't be constitutional by allowing debtors to petition the government for discharge and then allowing the government to provide one. The bankruptcy law intruded on lenders' property rights. As one bankruptcy scholar has noted, this power penetrates deeply into privately ordered relations. It implies that we have, in the bankruptcy power, constitutionally sanctioned the violation of property rights. Again, ultimately, the critics lose this fight, and by the time Congress passes its next bankruptcy law in 1867, it was widely understood to have this power to protect debtors through a voluntary statute. So I want to say more about the erosion now. So the first half of the book describes this and explains the constitutional developments that make up this increasingly protective federal regime of debt relief. And then the second half of the book examines the downturn. In 2005, Congress passed a bankruptcy statute called the Bankruptcy Abuse and Consumer Protection Act. And this was widely understood to scale back debtor protection. And there's been a lot of work done on the politics of the 1990s and how the credit card lobby was an important actor in bringing about the statute. But one of the things that we want to do in this book, and while we sort of agree with that characterization on the literature and also draw on it, we also see roots of this shift much earlier than the battle over this one statute. Indeed, we argue that as America shifted from an agrarian to an industrial society, wage earning debtors never took on debt relief as a core political issue. And so this led to an absence of the sort of pro-debtor politics that we saw in the 19th century. It's always hard to demonstrate the absence of something, of course. We tried. We examined every congressional hearing between 1950 and 2005 with the word bankruptcy in the title, and we excluded many or everything that wasn't relevant to the type of bankruptcy we were talking about, that weren't about personal or consumer bankruptcy. And then we classify the witnesses at the hearings. One of the things that you can see here is that bankruptcy experts, federal officials, banks, and creditor groups are pretty well represented in the second half of the 20th century, but that witnesses identifying as debtors or even representatives of civil rights organizations, women's groups, labor unions, consumer groups, only made a handful of appearances over this 55-year period. They're at the very left, left-hand side of this chart, again, only representing a small handful of appearances. So we offer a few explanations here. It's a different political economy. The stable macroeconomy meant that boom-bust cycle that Sarah just described is not present and sort of not available in some sense in the way that it taught farmers in the 19th century to organize around debt relief. In addition, many wage-earning debtors had a different history of access to credit than 19th century white farmers, and this history itself created obstacles to pro-debtor politics, especially for the kinds of membership-based organizations like labor unions, women's organizations, civil rights organizations that represented increasingly over-indebted consumers. So I'm going to use the rest of my time to just give you one example. So this is Julius Hobson. Hobson was a politician. He served in the DC City Council. He served in the school board too. He was a well-known activist in DC in the 1960s. And in 1966, Hobson, along with an attorney named William Higgs, proposed to mobilize low-income Black citizens, helping them to declare bankruptcy en masse. And so Hobson's vision here was that 20th century Black debtors could use the law of debt relief to free themselves from ruinous and an exploitative credit system. In a manifesto that he circulated to what he called Black power advocates, Hobson and Higgs described the existence of, quote, a set of laws enacted during the populist period to free the poor from the oppressive debt imposed upon them through usury and exploitation by the rich. Known as the federal bankruptcy laws, they've been scarcely touched by America's poor Black people, who remain largely ignorant of this powerful self-help weapon within their reach. Hobson was merely advocating that eligible consumer debtors use the existing law of debt relief. And still his message was met with resounding outrage and universal rejection. The Philadelphia Inquirer described it as a firebrand scheme, and a Tulsa Tribune columnist warned that his plan would undermine the growing Black middle class. Even the potential participants that Hobson and Higgs tried to enlist in their cause viewed this plan with skepticism. You can see this here in this letter that's excerpted on the slide, that the concern is basically that too much debt relief would deprive Black people of access to credit too. And for pretty understandable reasons, in the sense that debt relief renders credit more expensive. When loans become riskier for lenders, when the law might simply deprive them of repayment, the argument is that lenders will price that risk into future loans and then stop lending altogether. And some scholars have argued, offered this tension of between easy debt relief and available credit as an explanation for why debtors don't organize. Eric Posner is sort of a legal scholar who's very sort of associated with this particular argument. In other words, the cleavage between those who want more access to credit and those who are about to avail themselves of debt relief procedures is what prevents debtors from having much political voice. We agree with this in part, but in our book, we argue that this is a little bit more complicated. First, as we described, farmers faced the same tensions and yet chose debt relief anyway. Second, one of the things that we add to this conversation is how this perennial concern over access to credit interacted with the politics of racial and gender exclusion in credit at the time. And one thing to point out or to elaborate on this is, at precisely the same time that Hobson was arguing essentially for a debt strike, civil rights organizations were pushing for non-discrimination in access to credit, as well as for reinvestment into previously redlined neighborhoods. So not only do they see credit as necessary for their constituents, but they also became invested in arguments that highlighted the exclusion of their constituents as economically irrational and unsound. Okay. Perfect. Okay, so I'm gonna say a little bit about what's meant here. Actually, I just explained that, so I'm gonna just talk about the racialized safety net and sort of the aspect here, sort of where race overlaps with the politics of debt relief and also the politics of credit access. So, so we characterize in the book debt relief as protective social policy. Again, an imperfectly protective social policy for many reasons. But it's essential to describe whom that policy does and does not protect, as Hobson kind of described in our excerpt there too. So as I've described, a history of exclusion from access to credit makes it more difficult for civil rights organizations to call for debt relief because they're simultaneously dealing with demands from multiple constituents within their organizations. Second, proponents of generous debt relief have always argued that some people deserve the government's help to free them from oppressive obligations and the power of their creditors. And these arguments and the policies that they generate often entailed drawing boundaries between deserving and undeserving debtors and between those entitled to freedom from oppressive debts and those who weren't. We talk about in the book how this generally took on a racial component in that throughout much of American history, the quintessentially deserving debtor, literally called the honest but unfortunate debtor in congressional hearings and elsewhere, was a white family farmer. Both before and after the Civil War, white freedom from debt was often contrasted with Black slavery, and debt relief policies furthered freedom for a select group of white debtors. And then finally, by protecting land ownership, the 19th century's most generous debt relief policies offered protection to predominantly white households. Meanwhile, despite small gestures at land reform, Congress never seriously redistributed land to Black families. Instead, tenancy and sharecropping arrangement and state laws that grew up to entrench them famously used debt to virtually re-enslave Black farmers to white landowners after Reconstruction. And so over time, this emphasis on land gave way to an emphasis on protecting a debtor's assets, so that the American system of debt relief ultimately became far less valuable as a form of social protection to those who've been systematically excluded from amassing assets, as we just discussed. So again, and just to summarize, we argue here that both that the US has a much older federal safety net than most sort of American social policy and history of social policy scholarship points to, but also that the safety net had very many exclusionary dimensions. It protected predominantly white, middle and upper class debtors, and left many others exposed to the risks associated with economic precarity, and also facing punitive or extractive forms of debt at the very same time that it was protecting debtors from other forms of debt. Thank you.
All right, so thank you so much. We are now going to go into our question period, and I'm going to try and alternate between folks in the room and folks online. Let's start with folks in the room. Questions for Grant?
Sure. Thank you. These are all really interesting. I have little questions about pieces, but one thing that I wondered about looking at was the rise of these bankruptcy laws. Did that basically displace the debt relief laws of the 19th century? Did one just sort of replace the other? Because I kept looking on the timeline. Why did you need these debt relief laws if you had bankruptcy laws? Maybe you didn't. I know zero about the time.
This is a great question, and it actually, our answer is very important to our story. Okay. so I'm delighted that you asked it. And our story is, in fact, that over the course of the late 19th and early 20th century, a network of a combination of state and federal laws creates a sort of social safety net out of debt relief. And this starts in 1867 when national bankruptcy law is the creditors actually want, northern creditors in the wake of the Civil War are like, these southern states are passing all these stay laws. We can't possibly collect from these impoverished farmers who've just lost the Civil War. Congress, help us out. Step in and make it possible for us to overcome these state debt relief laws and get some money out of these debtors. And Western Democrats, the South is mostly not really in Congress yet, but Democrats from the West who are in Congress are like, no, we have all these homestead exemption laws and we love them and we need them. And we know, and they say we represent farmers, and farmers would much rather stay on their land than do your bankruptcy thing. Farmers don't want to liquidate a farm and, give away all the, get out of debt by losing their land. And so the Bankruptcy Act of 1867 says you can use this bankruptcy process to get a discharge, but it has to include, you get to keep all of the property that your state already lets you exempt from collection from creditors. And that feature sticks around and is still in our current bankruptcy law. And so it's because the state law is so protective that and because farmers understand themselves as debtors, they send representatives to Congress who then incorporate those state level protections explicitly into federal bankruptcy law, and bankruptcy law then becomes protective of debtors as well.
Do you think it's still in our laws for farmers or for homes?
There are still homestead exemptions, but they're still state, it's just, you can use your state level property exemptions when you declare bankruptcy using the national bankruptcy process.
So I have an online question here for Sarah. Did coverture extend to situations in which the husband was in prison for extensive periods?
Yeah, so there, theoretically, yes, but states would typically include various exceptions. Imprisonment was one, if a husband was declared insane was another, abandonment was another one. And in those cases, most states would have provisions that would allow women to do things like run a business, sign a contract, have a bank account, things like that. But what was key to that was that, let's say your husband abandoned you or was in prison and then he comes back. Coverture has, it's sort of been on hold, but he can now say, oh, lovely business you have there, that's mine now. So, so yes, it could kind of be suspended in many states through various legal mechanisms, but it wasn't permanent, I suppose, unless you're talking about life in prison, in which case potentially so. But if there was a chance that the man might return, he would have the opportunity to reclaim whatever wages or assets or savings the wife had sort of accumulated during that period.
Yeah, I also like totally. I have a lot of questions. So the first one is I was thinking about this in relation to like Kagan and adversarial legalism and total justice. That then led me to like 1841 is when we get this voluntary bankruptcy period. That's going to be a relatively lawyer-thin period of time. So what was like the support structure in place to allow farmers to access this system? That's a very American individualized system of kind of taking that. And the other one was just back to that quote. I wasn't able to read the whole thing, but was the language of contract used at the same time as a way of defending these shifts? Because what it looked like in that quote was I'm not asking for anything special. The problem here is we have a violation of the fundamental rules of contract. And so you exploited me, which then voids the contract. So I'm not doing anything except.
I think that was a response to the critics. So the critics said, this is absolutely in violation of contract rights, property rights as expressed in the contracts clause of the Constitution. So states can't impair the obligations of contract. And states would pass these laws saying, oh, no, you get to keep your land. And lenders would say, no, you can't do that. You're impairing the obligations of contract. And so the answer that debtors gave and their advocates gave was like, well, that wasn't really a fair. It's fine to enforce contracts, but that's really an unfair contract. So they weren't invoking contracts on their independently. They were sort of responding to the objection that this was a problem and that the job of the government is to just enforce a contract. And one of the things I think is so interesting about this is the 19th century is so often portrayed as a kind of Lockean liberal paradise. And here, even at the federal level, so this is even in the national governments, it's not just like little localities doing this stuff. It's the federal government saying, no, we're not going to enforce the contract. In fact, we're going to intercede between these two parties to the contract and rewrite it in the interests of social protection. So I mean, that's one of the things that drew us to this topic. Your other question, remind me.
So it was like lawyer
adversarial legalism. Yeah. This is a great question. We have a whole chapter on this. This is like the state building that most other countries have like an agency. You don't need a lawyer. You show up and you say, I can't repay my debts, and some, like a government official sits down and works through it. And throughout American history, especially starting in the New Deal, this is proposed. Like most debtors, they don't need to hire a lawyer. It's just going to be a very straightforward process. It's like filing taxes. You need some information, but like there should be a government agency that does this, that deals with bankruptcy filings, not a court. This is built in the courts, even though it is a lawyer-thin time. It's like the only administrative apparatus we have at the federal level in early America are courts. Only maybe too strong, but it's one of the few. And so also, as bankruptcy begins as an involuntary kind of criminal measure, so it was judicial for that reason. There were acts of bankruptcy that were criminal charges, could be accused of these acts of bankruptcy. So this was in the courts for that reason, but then I think stays in the courts in part because like who's gonna do it? Like, I guess the court. But Congress understands each time it passes a statute, it talks about like, well, how are judges going to administer this? That seems labor intensive. And so they write into the statute, well, they're going to be judge helpers. who are gonna, so sometimes they're called trustees or registrars, their name changes over time, but we get like an administrative apparatus built inside the judiciary. And eventually in the 20th century, those bankruptcy like helpers start to say, we want to become bankruptcy judges because they have a kind of quasi-judicial, quasi-administrative role. And they argue, well, we really should get this, we should be called judges and there should be a separate bankruptcy court that we preside over. And Congress does that in the 1970s. But there's a constitutional challenge because they're not Article 3 judges. They're not appointed, they don't have life tenure. And so that's like our one final constitutional controversy that these bankruptcy laws create. It's like, well, can you just make a judge in this way?
Thank you all for questions for unpack a little bit more the granting of property rights to women and the expansion west.
Mhm.
And the reason, because I've heard like a kind of the other side of the chicken and the egg story, which is, oh, the West is progressive, and so women move that way. And it sounds like you're saying because women had these rights, they were more able to move that way.
Yeah, so as far as it is the causality running that women are actually responding to this by moving west, I don't think that these laws are the only reason that women are choosing to move west, but you do hear explicit arguments from convention delegates and legislatures saying things like, we don't have any women, I'm single, I want to get married. Women aren't going to come here if we don't do something for them. Right. And so you get these sort of explicit appeals to one of the many reasons that we need to make sure that our laws are granting women some economic rights, is that otherwise we're all going to be stuck out here single and alone. And right. And in addition to that, right, and in addition to like the personal sadness of that potential for them, right, they're also concerned with gaining population, right? Without a certain level of population, they can't apply for statehood. The settlement project's not going to work without families instead of just a whole bunch of single guys. And so you have these factors that are wanting them to do various things to draw women west. And I wouldn't say Married Women's Property Acts are like a singular cause of women deciding to move west, but I think they're a factor that male political actors in legislatures and conventions saw as a potential way to draw women west.
Sorry, I just want to say we see the same thing about male debtors, that like Texas passes a homestead exemption law, and one of the arguments in the state legislature is like, we're going to get our population, build up our population this way, because debtors from the east will come here, and here the creditors can't touch them.
I might be misremembering on this part, but it sounded like you said this is also bringing like families to the West. And I wonder, I mean, that seems like it wouldn't solve at least the I need to get married.
Oh yeah, no, it would not solve the single men problem, but it would solve the settlement question, right? Of in order to both get greater population for the purposes of statehood, as well as what was seen as like this civilizing effect of having families, mothers, children, that was seen as part of this settlement project, that you had to have those elements in order for the West to become sort of quote unquote a civilized place.
And a kind of democratic, like republic, this sort of yeoman farmer language that what you want are families that own the land and farm it and aren't tenant farmers and aren't serfs that are themselves. This language of family goes along with a kind of like independent free citizen idea. I mean, the man with the wife.
Emma, can I ask a question?
Yeah,
Okay,
please.
yes. So one of the things that's, so in the whole modern discourse about eliminating student debt, one of the things that really strikes me is the very strong pushback to it, which is, takes the form of, why should they get debt relief when I didn't?
Yeah.
Something like that. Why should their disease get cured when mine didn't? Whatever. And I'm wondering, do you see evidence of those sorts of arguments being made in earlier time periods? And was there similar like sort of public resistance or editorial resistance to that relief?
Yes. So there's I think that moral hazard argument that we see with student debt, like this is going to promote irresponsibility if you tell people to take on loans and then you just tell them, never mind, I had to repay my loans, and that disciplined me in very healthy, productive, moral ways. And like, you're just going to forgive them. It'll be crisis. That we saw all along, that there's, and this distinction, as Chloe said, between the people, like even the advocates of debt relief were grappling with like, well, some debtors deserve it. And some debtors obviously don't deserve it. If they're out gambling away their money, we don't want to forgive that loan. We want to forgive the person who tried his best and just couldn't manage to repay. And so I think that echoes of that concern with like who deserves it and how would we know? I think that's just kind of inherent in the politics of debt relief.
And I mean, you also see the sort of the discourse in the 19th century, and then I think there's some of it today too, of sort of in terms of constructing this honest but deserving debtor. And again, like, this is so explicit that this is what they're trying, that this is how they're talking about it, that there is a sort of it's these people for these reasons. They often invoke issues outside of their control, disasters, right? Economic crises, things that make it so that otherwise they of course would be sort of willing to make good on their contract, but it's just this other thing that's affecting everybody, and that's completely outside of our hands. And you see that too today, an effort with the construction of student debt relief. So again, strike debt's a good example of this. Arguing that this is first of all, this grows out of the financial crisis and the this rise in unemployment among college graduates. And you see this argument that, well, we're deserving, or this is something that is deserved at least because of this economic calamity that's out of our control. Students have been required through forces outside of their control to take on these huge debts in order to pay for a credential that they're told that they need. And now the labor market can't actually produce that outcome that they are being asked that they were counting on. And so that sort of points to the way that they're also trying to construct this against that narrative of, well, do you deserve this, or sort of why should this group get debt relief when others don't.
This is reminding me so much of it might be Peter Scotchpole's book about the Tea Party, talking about the way Tea Party members talk about the social welfare state, basically, and Social Security and Medicare. It's like, no, I deserve that. I paid into it, or these circumstances were beyond my control, but I'm concerned about other people who are undeserving. And like, there's a lot of packed into that, obviously. But it seems like it's similar.
And that's so interesting. We hadn't discussed that, but and we talk about the changing rhetoric around debt relief leading up to the 2005 Bankruptcy Abuse and Consumer Protection Act. The fact that you would call it bankruptcy abuse itself is something that's new, and that develops over time. The idea that one could be abusing the bankruptcy system rather than just using the law as it's designated and as it's sort of available to them. And so I think we need to think about this a little bit more for our own project as sort of maybe even a precursor to the Tea Party rhetoric, because this is building up for about a decade but before that, but there's also sort of a similar logic there too.
Yeah. And I'll just quickly jump in and say, I think you see these morality arguments on both sides with the married women's debt-free estate laws as well. On the one hand, a lot of rhetoric that echoes the temperance movement of poor, defenseless, virtuous wives and mothers whose husband is out with the rum seller, drinking away her fortune, and he's gone deeply in debt over alcohol, and she is virtuous and needs to be protected. And then on the other hand, you also see debates around concerns of fraud, of, well, if we don't sort of design all the particulars of this law correctly, can't a man just gift all of his property to his wife and suddenly it's protected? And do we have these couples who are similar to what you're saying, like misusing the law for a purpose that it wasn't meant for by defrauding the system? So it's interesting to see a lot of the same echoes.
Yeah.
Thank you. And issues of this is I think of the international cross-national question. Use Act. And in the international Jubilee movement, I wonder if you see yeah, be weighing on either side or even like potentially among this question of conservative, especially around like temperance and this idea of the drunkard here is like very interesting. And then one other quick thing that's not related. It's about, actually, sorry, one other thing is really also about estate tax and sort of back like for and then just one quick thing you asked about like suggestions for the draft showing data, and you've mentioned a few other things that I thought would be super interesting to see there. The first thing that I wanted to see was like an x-axis that hasn't been that looks like it's really fluid, but there's actually a huge gap in the early 20th century. And so that I kind of was curious about and would love to see sort of explained. And then also if you have the gray bars in the background for the boom and bust cycles, right? So when
it's
lending,
great. Yep.
When is credit more available and when is debt higher? Maybe there's no relationship, which would be a footnote, but also interesting. Maybe there is.
No, I think there is
That's-
one.
That's
Yeah.
great. No, those
Thank
are,
you.
so now we have to admit that we're not very good at making drafts. But we can talk to someone who is good at making drafts and include this. That's super helpful. So I have to say, Emily, you should weigh in too. We've gotten the religion question before, and it's super interesting. We've looked into the 20th century for sort of evidence of efforts to sort of it's by sort of religious organizations to try to discuss the issue or to try to take it up, and we've come up empty. Although I wouldn't say that I think that might be a function more of how we're going about this. We did a lot of sort of historical newspaper searches with a research assistant, and I haven't really thought about as much the temperance movement though, and sort of thinking about that's just a great suggestion. So I guess I would thank you for that.
You know, the one thing that occurs to me is that Hobson complains. He tries to
Yeah.
go to Black churches.
Well, so yeah,
and because he's like this wildly exploitative credit system in Black neighborhood, things are sold on installments for like no money down and with very good collection mechanisms. And so people are just like really taken advantage of, and very shoddy goods that don't last and then are repossessed and then they owe money on them. And it's widely understood as we found lots of Black newspapers being like, this is a huge problem. And Hobson goes to Black churches and says, help me. And he complained, we don't have any corroborating evidence of this, but he said that the leaders of these churches were not into it, and that they were part of the problem of perpetuating a kind of moral vision that involved making good on your promises.
Yeah.
And that he was like, this is ridiculous. What we have to do is recognize that we're being exploited and reject any stigma associated with that. And he points at the populists and he's like, they did it, we could do it, but it doesn't take off.
but we don't, to be honest, we don't know if it doesn't sort of, if it's not picked up, if it's picked up by other religious figures or like that. That's something that we've just had difficulty answering and figuring out. So again, this is an area where if there are suggestions,
if you know how to
would
do
be
that,
extremely
tell us.
helpful.
I just think of the Second Great Awakening. For the earlier part of the study. But there was part of that theology was you have to personally take responsibility to prove yourself your savior and save your soul. So the individualist responsibility, even though part of that theology was very progressive on things like the abolition of slavery, I can see it being very individualistly oriented. Here.
Sorry.
And just one other quick thing on it. So did the 2008 financial crash not lead to any mobilization against the 2005?
That is one of the things we just.
Yeah, so this is, so what we are kind of not super well evidenced argument, but we really think this is what's going on, is that over the course of the 19th century, that instability teaches people who have to take on debt that this is going to be an important political issue. And so organized farmers store this knowledge over time. And immediately after a financial crisis, they're like, debt relief. And they remember the last laws and they say, we just did this 30 years ago, pass some new ones. And so counterintuitively, that boom bust cycle, which in some senses is very bad for debtors because each deflationary episode really puts the screws to debtors, it's good for debtor organizing. Whereas in the 20th century, we get a much more stable macroeconomy. We don't have a big deflationary episode. And farmers still understand themselves as debtors, but fewer and fewer Americans are farmers. They're now wage earners. And wage earners organize, certainly. I mean, we get major flowering of labor organizing, but labor unions don't take up debt as a central issue.
Although they know that it is an issue faced by their members, they are aware of this.
They set up credit unions. We found a column in the AFL-CIO newsletter that's like how to deal with your debt. But instead of saying the things that the farmers newspapers say, which is it's not your fault, go to the state, demand help, they're like, try buying cheaper shoes for your children. And so that sort of shift in the understanding of debt as a collective political issue versus a personal budgeting issue is one of the things we highlight. And we blame in part the stability of the economy. But right after the 2008 crisis, organizations like Occupy Wall Street springs up and it starts talking about debt. And then it's like little offshoots like strike debt begin to say, hey, this crisis wasn't our fault. Also, houses are being foreclosed on in huge numbers again. And it's like the same rhetoric from the 1890s. These greedy lenders, these innocent homeowners who are being kicked out of their homes. How can we have a functional society if people can't stay in their homes? And so it's nothing like, I mean, it's not nearly as robust as we see in the 19th century, where everyone knows debt. That's an important political issue. But we think there's a kind of emerging in this newly kind of post-Keynesian economy, where with much less of a social safety net, with much more instability, debt is again emerging on the political agenda. We think that's not coincidental.
Okay, you started with this is great, thank you. And I know Sarah's book better because of her book workshop and reading a good chunk of it. So I'll focus my question to Chloe and Emily.
Mm-hmm.
But you started with the hook about needing a title, and so I was workshopping titles.
Yeah,
Thank you.
Writing.
Yes. That's
But then
great.
That ended up being a good kind of heuristic, and I'm going to use it again for listening to a talk for kind of what's going on in the larger project and kind of, so I wanted to back up and get oriented about what subfields are you pitching this book to in political science? Is it APD? Is it politics? Is it political economy? What subfields?
All of them. You found our real.
Subfields, because then I want to say another thing about what I'm hearing is, and maybe if after all that, I might be able to throw out a couple ideas.
Well, I think part of the great strength of having two authors is that we can see so many literatures to which this research might speak. And it's also a vulnerability because we can't seem to prioritize audiences, but let me give you a menu of possibilities. So one is the sort of development of the American state. We had this welfare state, or at least the social safety net before people have recognized that one existed. And it wasn't an urban working class movement. It was a rural farmer movement. But we still had a kind of national commitment to safety net. So that's a kind of APD angle. One is a constitutional argument about this sort of property rights. This story about American constitutionalism is solely devoted to contracts and private property, but that's never been true. That there have always been these countervailing traditions, and they've had a real impact on how we've read and understood and lived our Constitution. So to sort of rewrite that account of I tried to do that with state constitutions, but we're trying to do that also with the federal Constitution. And then a third is a kind of policy, like public policy type argument. Do you want to say more about that?
Well, I mean, so in the sense this, and I think this is what gets to your question too about sort of like multiple audiences, is that the public policy question comes up much more in the 20th century, so because there's so much of the action in the 19th century is about sort of, yes, policy, but these policies are short-lived, and they also involve these constitutional controversies that more or less sort of disappear by the 20th century, with the exception, but it's a very different controversy than the earlier ones of the Article 3 judges. But sort of like the politics of public policy and the relationship between organizing social movements, economic sort of conditions and policy making. And so
Okay.
there's a story in the 20th century, and this is why no one should ever try to write 2 centuries of political history. It turns out, but the story, of the decline, we can tell the story of the rise of the debt relief regime, the sort of protective debt relief regime, in language that just in a way that basically is focused on sort of APD and constitutional development. Whereas to explain the decline of the regime, you kind of have to go resort to a different set of tools. You need to think about the changing interest group constellations. Some of those themselves grew up around policies from like the 1890s and such. And again, the sort of shifting political economy. And so this is where the issue if we were like stopping, right, like 1898 would be the perfect place to stop in some sense, because we have an easier story, and it's like that's like the creation of what we sort of think of as the modern bankruptcy code, even if it's sort of like just most of the features that we kind of like fresh start. At least I'm thinking about fresh start. And the development of like a sort of bureaucratic administration, but through the courts. But if you want to go past that, and most people want to know, like we're more interested in the recent too, then it does kind of invoke like a different set of literatures and a different set of questions. So I'm happy to hear your title suggestions on that now.
Okay, so then let me reflect some stuff back.
Yeah.
I was like puzzling across your 2 projects. To me, Sarah's book looks like it's a story. It looks like topic-wise, initially, when you first hear what Sarah's working on. You think it's going to be a story about women, movements, agency, changes in law, but it turns out to be a story, in my reading, about property, power, and empire, where gender, race, and class are implicit subtext of this book. Like, her book illuminates these really interesting underlying dynamics about race, gender, and class, right? That where this thing is moving. And it's an interesting potential dialogue with something like Paul Freimer's Building the American Empire, because it's also about empire and how empire moves through consolidation of the state through the activities of ordinary people, including economically. The state has to, in my reading, make these accommodations around debt because it needs to populate the empire. And it needs ordinary people to do the work of that, which is what Freimer argues. That it's not until ordinary people move to the next line of the West that the state consolidates instead of going off to the same thing. Right? And so it's not until the state moves, it consolidates as it goes. It has to make all these concessions, including to Lockean contract law, right? As it goes. And so it will do things that it wouldn't otherwise do because it needs the people to do it, right? Your story in my reading is about, then I was going to ask you, like, so who do you see as the agents or forces or actors? What I heard was a story about law, economy, and agency or movements, which then becomes more about agencies and bureaucracies. So it starts as movements, law, the economy in the 19th century and the 18th century. There at the beginning, the shades of movement, right? And the subtext is class and race. So you could call it the red, white, and green.
Oh, I love it. That's fabulous.
The red, white, and green, and then it would get at being in the red, right? The green and money, and like white people, right? And then your subtext, and like the privilege of white people, and then your current title, the political economy of blah blah blah, is your subtext.
Oh, that's really good.
Wow.
Thank
You
you.
should charge for that.
Absolutely.
That was nice.
That's really good.
In fact, my reading is right.
I think your reading is right. Thank you so much.
So can I quickly go to an
That's
online
great.
question? Asking, did the transition from civil unions to marriage for same-sex couples result in court cases associated with debt relief among spouses? An additional modern wrinkle.
Yeah, I don't know. I
don't know.
don't know the
Very
answer to
good
that question. It's a great question. Yeah. You'll have to read it.
Okay.
I'll try to.
Okay.
No,
Yeah,
no,
I'm
I
not
mean,
sure, but
that's worth thinking about more. Yeah, I don't know.
I mean, I know there's
wish
been a
I'd-
lot around inheritance.
Yeah.
But, and government benefits like Social Security, but debt stuff, I don't know.
Yeah. Apparently we kind of stopped in 2005.
Yeah, we
so-
did. We
So,
started.
You have
but
to pick a
that's,
point.
that's a great
Great
question.
And it gets at this notion of how debt relief, and that Sarah's work does so well, and that I think we should try to incorporate more, that debt relief and construction of the family are
Mhm.
intimately connected from the start. That like what we want, what Americans want family to look like is often driving debt relief policy or politics.
Yeah, the hegemonic family.
I think we have time for just one more question. I want to go to a very patient department. My department chair is currently going through my annual review. I'll give him the last question.
And I gotta say that your title is way better than mine. I had One Nation Under Debt.
Oh,
like that's
good too.
Right, today would be a good day to cancel farm debt or something like that.
But so the other two things are just, I think it's kind of talking to my students about literature reviews today, and I'm tired of the caffeine. But the two things that popped in my head that I wanted to ask about again were so thinking about like why labor doesn't organize around these things. It made me think of a lot of the American labor union for that, but it's all about individualizing, and so we don't get labor politics, we get labor unions. And so I was wondering if that factored into this, and I was also thinking about debt for wage earners to company stores.
Yes.
How that privatizes things, takes it out of the state. And the other one was jumping way ahead. So Sara Chatfield's book and Holmes McCann's book, when you were talking about the 2005 law, I was wondering if there's any connection to like the anti-tort movement and the stigmatization of the use of civil law that way, and talking about the abuse of law through torts, if that works its way into this, and if it's then tied into Sara Chatfield's visual country.
Those are great questions. Let me start with the wage earner debt. So part of our story is that as in the 1930s, special bankruptcy provisions get written for wage earners. And they don't, wage earners can choose between the general bankruptcy provision and the special wage earner ones, but the wage earner ones are shockingly, although the 1930s is a real high point of labor organizing, labor does not show up to Congress to help craft these. In fact, only creditors and these bankruptcy officials show up, and they have this plan that that wage earners are not really, they say they don't really want to declare bankruptcy. What they want to do is pay back their debts in full. They just need a little more time. And it's mostly like the Retail Creditmen's Association that advances this argument. and Congress crafts a law along these lines saying like, okay, so for wage earners, they're going to go on a repayment plan. And it'll stretch over 2 to 5 years. They'll repay their debts in full. And then if there's some remaining debts, like after this 5-year plan, maybe those can be forgiven, but mostly they're going to be like trying to repay. And that becomes chapter 13, which is the thing that creditors throughout the 20th century and then eventually Republicans pick up. And in the 2005 law, one of the things that is so much less protective is that it forces, this 2005 law forces more people to use this.
Because it
repayment
turned out
plan.
that wage earners didn't want to use chapter 13. And so it was created but seldom used until it was sort of forced on more people after 2005.
So then the question is, well, why not? Like, why didn't labor get on this issue sooner? What was it about labor unions that stopped them from seeing this the way that farmers had? So one of our explanations is this kind of macroeconomic story. The farmers had been debtors for a long time through many boom bust cycles, and laborers were just much newer to credit. Like they didn't even really get credit until the early 20th century. So they didn't have that learning experience. Another is maybe like they just had much bigger fish to fry, like just the right to unionize was a big political battle. And then a third, and this we owe entirely to Chloe, is that they're actually, labor unions become creditors in a lot of corporate bankruptcies. So corporations are using corporate bankruptcy to escape their contracts with labor unions. And so labor unions show up to court increasingly to demand that bankruptcy be less protective of the bankrupt party, here the company. And so perhaps that orientation, although, you know, there's no inherent reason they couldn't do that and say, but personal bankruptcy should be different. It may be that that commitment kind of pushes them in a different direction. And then you had one more question. Oh, I'm sorry.
Wow, okay, this has been great. I want to just quickly, brief announcement. The Center on American Politics is hosting a discussion next Tuesday on the Dobbs Supreme Court case and Roe and the future of abortion rights. It's going to be Tuesday at 3 p.m. on Zoom. That will include Josh Wilson, it'll include Amanda Hollis-Brisky and others. So watch for the announcement on that. But as for now, thank you all for being here. Thanks for those of you who are online, and please thank our panelists. And
Thank you, sir.
scene.
Yeah, thank you for doing this.
Yeah, and
Thank
thank
you
you
for
us a
that.
chat.
Thank
Oh my
you.
gosh,
Such a
thank you guys
pleasure.
for coming.